Welcome to Bloomberg Quint. You're watching The Fine Print. It's the farmers of Gujarat versus the World Bank's financial arm, and the battleground is the United States Supreme Court. At the center of this battle is the Tata's Mundra power plant. The US Supreme Court has to decide for the first time whether World Bank's private lending arm, International Finance Corporation or IFC, can be sued. The case dates back to 2015 when fishing communities and farmers from Mundra in Gujarat dragged IFC to court. Now, IFC had loaned $450 million for the construction of the Tata Mundra power plant in 2008. The loan agreement gave IFC supervisory authority over the project, which included implementation of an environmental and social action plan. The farmers alleged that IFC's failure to supervise this plan had caused environmental damage. For instance, neighboring communities couldn't get access to fresh water because the construction of the plant caused saltwater intrusion into groundwater. The plant's cooling system, they had alleged, discharged thermal pollution into the seas, killing marine life and the source of farmers' income. IFC sought dismissal of these complaints on grounds that it has absolute immunity from being sued as per the International Organizations Immunities Act. The District Court of Columbia that first heard this case upheld IFC's argument following a precedent laid down in Atkinson judgment. It held that the Immunities Act gave international organizations the same immunity as is enjoyed by foreign governments. Interestingly, the fact that IFC's Article of Agreement contained an express waiver of immunity did not sway the court. After several failed appeals, the farming communities have now reached the Supreme Court that has agreed to hear the matter. In short, the communities are arguing that organizations like IFC are not above the law, given that they engage in strict commercial activity of lending money and must be held accountable when their projects harm communities. So will this argument find favor with the US Supreme Court? Joining me with their views are Joe Athalia, Executive Director, Center for Financial Accountability, and John Echeverria, Professor of Law at Vermont Law School. Gentlemen, welcome to The Fine Print. Joe, the Center for Financial Accountability has been assisting the farming and fishing communities in this litigation. Now, usually when it comes to environmental harm, it's the companies that are dragged to court. So what prompted these communities around the Mundra plant to sue the lender, in this case IFC, before the district court?
Hi. There are two aspects to it. One of them is, it's also the fish workers who are kind of getting affected by the project because of the effluence that you said is put in the sea. IFC started lending this project in 2008. And until some of us kind of told the communities about IFC's involvement, they were completely clueless about it. In 2001, when they went to the compliance advisor ombudsman, the accountability mechanism of IFC, they raised a range of issues, both environmental and social, the lapses of studies, no cumulative impact assessment, and a lot of kind of such issues. In 2013, when the report came out, it almost confirmed all the concerns raised by the fish workers and the farmers of that area. Until now, the case was filed in 2015, but until now, IFC has not acted upon the findings of the CAO. CAO doesn't have any implementing powers. It has only kind of recommendatory powers, and hence they recommended, IFC ignored it, and people were left with no option than to kind of seek judicial remedy.
Okay, but why the lender in this case? Why not, let's say, the Tatas? Were there any actions that these communities took here back in India that were that failed, and then they had to take an action against the lender in this case?
The Tata Mundra project is not a standalone project in Mundra. It's just adjacent to the Adani power project. Both of them even share a single intake channel. It's so closely located. The communities there have sought judicial intervention in Adani's case, both again on the social and environmental grounds, and they didn't kind of get any relief. And they were advised that since this project is just adjacent to that, similar fate could be kind of meted in this case as well. However, they have kind of tried all other avenues, including the Pollution Control Board, including the collector, the administration, the state government, I mean, they have approached all other avenues and they have not kind of got any relief. A larger point here is also that anywhere, I mean, world over, the lenders kind of lend money for such kind of bad projects, which kind of cause huge damage to environment and to the people, and they go scot-free. Nobody holds them accountable. So here is also the larger point here is the lenders being held accountable for the lending that they do to kind of projects which cause immense damage to the environment and to the people.
Okay, let me get Professor John in. Professor John, could you weigh in on how U.S. courts have looked at actions against organizations like IFC, and have these organizations always enjoyed immunity from judicial processes?
Well, the degree of immunity that governments enjoy in federal courts has actually evolved over time. The basic traditional rule is that the sovereign, whether it's the United States or a state of the United States or a foreign sovereign, is immune from suit in federal courts. But that has evolved over time, and the current U.S. view is reflected in something called the Foreign Sovereign Immunities Act, which was adopted in 1976, which draws a distinction between governmental sovereign acts, like the enactment of legislation, and commercial acts. So when the government steps out of its sovereign role and acts very much like a private business, or as in this case, like a private lender, the government can be held liable despite the immunity doctrine in U.S. courts. And the very specific issue in this case is whether the doctrine, the version of sovereign immunity doctrine as laid out in the Foreign Sovereign Immunities Act, which makes this distinction between governmental actions and commercial actions, applies in this case or not. If the D.C. Circuit said that under the International Organizations Immunities Act adopted in 1945, the immunity doctrine governing international organizations was essentially frozen in time as of 1945, and that there is absolute immunity. The petitioners are arguing that no, the immunity that is available under the Immunities Act, the International Organizations Immunities Act, does properly evolve with time, and under the modern U.S. view of sovereign immunity, there's a commercial exception to the immunities doctrine, and that the Tata should be subject to suit. So it's a fairly narrow, quite technical legal issue regarding the scope of sovereign immunity. People who practice law in front of the U.S. Supreme Court commonly say that the Supreme Court grants cert to reverse, not to affirm. And I would expect that the Supreme Court would reverse the D.C. Circuit opinion, accept the dissenting opinion of Judge Nina Pillard, and conclude that the IFC is subject to suit in this case.
Sure. Joe, you alluded to this earlier, that IFC's own compliance advisor, Ombudsman, had concluded that IFC had failed to adequately supervise the project. But the district court had refused to rely on this report, saying it would disincentivize organizations from setting up such internal review processes. Would you agree with this view? And if this happened, what would be the implications of this conclusion?
On the contrary, I mean, the internal accountability mechanisms didn't come voluntarily from these institutions. It came because of people's struggles from all over the world for such a long time. To start with, it was the inspection panel at the World Bank, the first accountability mechanism any multilateral bank had. It was directly because of the struggle of the people of, affected by the Sada Sarovar project in India, that the inspection panel was set up. And subsequently, other banks also kind of established these internal mechanisms. Just because, what we are arguing is that these mechanisms needs to have much more tooth. I mean, they are toothless in some way, because They only can kind of report the kind of violations. They cannot kind of even suggest any actions on that. And that exactly is the loophole that IFC has taken, not to kind of act on it. And all these years, I mean, it's 2013, it's 5 years now, IFC has not even acted on even one findings of CAO. I mean, institutions like CAO needs to be kind of empowered with much more power to kind of implement, to oversee the this implementation, and even take punitive action on the people who are kind of failing to kind of act on it.
Okay, I'm not sure if it is one of the prayers of the petitioners in this case, but Professor John, is that something that the Supreme Court can lay down, that internal review committees like these should be given more teeth?
No, the court won't be addressing that issue. They'll be focusing in a very narrow way on this threshold question of whether or not the IFC enjoys immunity. And assuming the court reverses and says there is not immunity, then they will send the case back down to the federal district court in Washington, D.C., where all the merits of the claims will be evaluated. And and it's possible the district court would address the issue you're posing. I agree that the ombudsman was created in response to popular pressure and concern about irresponsible World Bank activities. But I think it was created against a backdrop that the World Bank and its arms were immune from suit. I wouldn't be surprised if the ombudsman process, which critics claim is not very effective anyway, might wither if it became possible for adversely affected individuals and communities to bring lawsuits and recover damages.
Okay, Professor John, the other part that I found curious in the entire case was that the district court chose to not consider the fact that IFC's article of agreement had itself waived immunities from such actions. They've interpreted it to mean that the immunity can be waived only if it's in the organization's interest. What, in your opinion, led the court to rule so, and is that something that the Supreme Court is also likely to look at?
Possibly. I think that ruling was supported by precedent in the D.C. Court of Appeals. I think it's based on a strained reading of the statute and of the articles setting up the IFC. I think if the Supreme Court reverses on the threshold question of whether or not commercial activities are not protected by sovereign immunity, the court will simply dispose of the case on that basis. Because if the IFC cannot assert sovereign immunity, then the question of whether or not they've waived their sovereign immunity becomes moot.
You know, in the judgment that came out of the circuit court, Judge Pillard had observed, she had written a concurring judgment, but she had also noted that the precedents on whether international organizations like IFC can be sued are incorrect. She has gone to the extent of saying, were I not bound by the precedent, I would reject it. Professor John, will this, in your opinion, at all influence the way the Supreme Court views this case?
Well, it's always significant to the Supreme Court when a lower federal court, and particularly a lower federal court as prestigious as the D.C. Circuit, is divided on a particular question of law. And Judge Pillard is a very distinguished judge, and so they're going to take seriously the fact that the issue has generated a dispute in the court below. I think what should give the petitioners hope is that the majority in the court below essentially relied on their longstanding precedent and said, this has always been our view, and we're sticking to our view. Judge Pillard, on the other hand, really went back to first principles and evaluated the merits of the argument about whether immunity applies. And I think on balance, her argument is more persuasive than that of the majority. And as I say, I would expect that the Supreme Court will adopt the opinion that she laid out in her separate concurring opinion.
Professor John, I'm sure the farming communities would be delighted with your view. Joe, how are you looking at this? If the Supreme Court were to rule in favor of the farming and fishing community, what could be the implications of it? Do you believe that it could adversely impact funding of projects in developing countries? Because organizations like IFC fund projects that cannot attract sufficient private capital. And if this were to come in, the immunity were to go away, would IFC-like organizations become more picky in the projects that they fund?
It's close to 8 decades since the Immunity Act was passed. And the discourse on human rights and accountability have kind of gone too far from where it was 8 decades back. It's not just, in the realm of financiers, lenders and banks and finance alone. It's also about every sphere of governance. And what we hope is that the Supreme Court will kind of consider the advance discourse on the human rights and accountability and would consider that when they decide upon this case. That IFC is held accountable is not going to kind of impact the lending at all, because what we are talking is not against lending. What we are talking is responsible lending. There needs to be kind of systems to kind of hold lenders, whether it's international or even national, systems to kind of hold them accountable. And that is also in line with what the World Bank is kind of talking about. They talk about accountability and transparency day in and day out. And we are just kind of asking them to kind of implement it in all levels of their institution.
Okay. Professor John, last word to you. Would you agree with what Joe is saying, that it would make organizations like IFC and similar organizations more accountable, or as they had argued in their petitions, would it open floodgates of litigation for them to handle?
Well, those are two sides of the same coin, arguably. It's worth noting that one possible response to a victory by the petitioners in the Supreme Court would be new legislation in Congress reestablishing the immunity of international organizations. I don't think that's likely, but it's possible. But if the petitioners prevail and if Congress does not act, I think the decision would likely have a profound impact on the IFC. I doubt that their ability to raise funds and to make investments would be significantly affected, but I think the conduct of their operations would be, and that they would be compelled, and many would think this would be a good thing, to scrutinize and oversee the projects that they're financing and for which they're taking responsibility much more closely. If they're going to be held liable for the adverse community impacts of the projects they finance, they would be much more careful in the future to ensure that the projects they're financing don't generate those kinds of impacts.
Well, it is an important case, and the US Supreme Court will start hearing the matter in October later this year. The outcome in this case will determine if IFC-like organizations become more accountable. Professor John, Joe, thank you very much for joining me with your views on the fine print.